it is working, which it is. And so I'm going to turn it over to the judges and say good luck.
Congratulations, day 2 of the Nationals. Take a deep breath. We're excited to go. We're going to go with question 2, but before we do that, we're going to take the opportunity to introduce ourselves, get you comfortable with that, and give you a little background, and then get into the question, but ask you to introduce yourself before we do that. My name is Mark Simons. I'm an attorney in the great state of Nevada. And my selling point to you is keep doing this because you can be paid to talk, just like you're doing. People will actually pay you to read and talk. So it's amazing, the coolest thing ever. Been judging and coaching for about the past 12 years. Good luck. I'm excited to hear what you guys have to say.
My name is Charlie Hinderleiter. I'm the Director of Government Affairs for St. Louis Realtors in St. Louis, Missouri. I'm a past political science professor, and deeper in my past, I was a student in the We the People program, sitting on, well, I guess it's the other side of the camera, not the table today. But I am looking forward to our conversation.
Hi, I'm Karen Melton from New York. I'm a lawyer by training. I'm currently the Chief of Staff in the Office of the Inspector General for the Metropolitan Transportation Authority. That's the New York State agency that oversees the transportation system for New York City and the greater New York metropolitan area. Prior to this, I was a circuit executive for the Second Circuit for many years, overseeing the 13 federal courts in the states of New York, Vermont, and Connecticut, where, believe it or not, we spend a lot of time talking about habeas corpus. So I'm here to tell you, if you really like habeas corpus, the federal courts may be for you. Anyways, looking forward to the conversation.
Hello, we are Unit 1 from Grant High School in Portland, Oregon. I'm Cohen Hegelke.
I'm Jared Smith.
I'm MJ Sassy.
I'm Maddie Snyder.
I'm Evan Hawkert, and this is our teacher, Ms. Di Pasquale.
Thank you. All right, I'll be reading question 2. Take a deep breath, get excited, and get ready. And when I conclude the question, feel free to begin. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government?
Alexander Hamilton wrote in Federalist 84, "The establishment of the writ of habeas corpus is perhaps the greatest security to liberty and republicanism than any the Constitution contains." There are multiple forms of the writ of habeas corpus, with its most common form being ad subjudiendo. A petition for this writ is filed by or on behalf of an imprisoned person. If the court issues the writ, the prisoner's custodian must bring them to court to determine the lawfulness of their detention. Habeas corpus is important to the principle of limited government, as it prevents the government from imprisoning people illegally or indefinitely.
The Constitution's suspension clause can render habeas corpus less effective in limiting government. The clause allows for suspension of the writ when in cases of rebellion or invasion, the public safety may require it. Anti-federalists worried this clause gave the federal government excessive power, a fear tested during the Civil War, when President Lincoln suspended habeas corpus amid fears of a Confederate rebellion. The origin of rights protectable by habeas corpus can be traced to Clause 39 of the 1215 Magna Carta, but Parliament officially enshrined the writ for Englishmen with the Habeas Corpus Act of 1679.
Habeas corpus was incorporated in the Constitution as an assumed right under the suspension clause, so the legal function of the writ developed through common and statutory law. This began at the federal level with the Judiciary Act of 1789, which granted federal courts the power to issue the writ to prisoners in federal custody or committed for trial before a federal court. The writ of habeas corpus did not become the appellate tool it is today until its expansion during Reconstruction. In 1867, Congress extended the writ to state prisoners, claiming that their detention violated a federal right, and allowed for habeas corpus to be used post-conviction. However, the 1944 Supreme Court case Ex parte Hoc codified an 1886 precedent requiring the exhaustion of all state remedies before seeking habeas in federal courts.
Extensions of the writ in the mid-20th century focused on providing due process. The 1953 decision, Brown v. Allen, permitted federal courts to re-examine constitutional issues previously tried by state courts. This resulted in a new supervisory role of the federal courts over state judicial systems, which is how the writ is mostly utilized today. However, under a 1966 provision, factual findings of state courts are normally presumed to be correct, placing the burden on the petitioner to disprove them. In response to prolonged death penalty cases and perceived habeas corpus abuses, Congress passed the Anti-Terrorism and Effective Death Penalty Act of 1996, severely limiting the scope of the writ. The act included a one-year statute of limitations, reinforced the exhaustion requirement, and barred repetitive habeas petitions.
Since habeas corpus advances the rule of law and can be suspended in certain circumstances, habeas does not pose an unreasonable burden on the government. An example of habeas corpus as a reasonable burden is evident in the 2008 Supreme Court case, Boumediene v. Bush, which held that detainees at Guantanamo Bay Naval Base have a constitutional right to seek habeas corpus. However, some worry this decision threatens national security, such as Justice Scalia, who wrote in his dissent that it will almost certainly cause more Americans to be killed. Regardless of the potential burden on government, the importance of habeas corpus in the realms of immigration, death penalty law, and prisoner rights makes it, as Hamilton said, perhaps the greatest security of liberty, especially for today's marginalized populations. Thank you. We are ready for your questions.
All right, thank you for that. So let's talk a little bit about the historical underpinnings of habeas corpus and how and why the founders thought it was so imperative. I mean, you quoted Hamilton. Hamilton said it's the greatest securing of liberty. But why did the founders feel that way? We have a constitution, we have a Bill of Rights. They put a lot of individual rights, natural rights in those documents. Why do we need habeas corpus if we have a written constitution and a written Bill of Rights, unlike England?
Alexander Hamilton said in Federalist 84, he notes that it's that arbitrary and indefinite imprisonment has long been a tool of tyranny. Habeas corpus, of course, is a means of fighting against this indefinite and arbitrary imprisonment. So following Hamilton's reasoning, it is also a tool against tyranny.
And one of the things that William Blackstone writes in the Commentaries on the Laws of England, which was widely circulated amongst the founders and is largely how they got their ideas on English common law, was that essentially all of the rights that we know flow from habeas corpus, because without them, there wouldn't be a way to enforce them and to ensure that they are actually being recognized by the government.
According to Kermit Roosevelt, who is a University of Pennsylvania law professor, habeas corpus is more about the structure of government, as its purpose is to reinforce the separation of powers to enable the three branches of government to cooperate in denying an individual liberty, as much as it is an individual liberty.
In a historical sense, back in 1628 in England, probably the most well-known case was the Five Knights case, or Darnell's case, in which the king imprisoned 5 nobles who refused to pay taxes to him, and they were in the court ruled that they were legally imprisoned because it was the king's prerogative to. But this led to the Habeas Corpus Act, and this was kind of the catalyst for the use of habeas corpus to check the executive.
How does the writ of habeas corpus fit within the due process protections of the 5th and 14th Amendment? How do they interact?
Alexander Hamilton in Federalist 84 stated that due process is the right secured, and habeas corpus is the instrument by which due process can be insisted upon by a citizen who's illegally imprisoned. So in this way, due process is the right and habeas corpus is the remedy.
Under Title 28 U.S. Code Section 2254, a federal judge can entertain a writ of habeas corpus if it's made on the grounds that the detainees confinement is in violation of the Constitution, any treaties, or federal laws. So it could be made on the grounds that the detainee's confinement is in violation of the due process rights from the Fifth Amendment.
Habeas corpus is also an important vehicle for securing other constitutional rights, such as the ineffective assistance of counsel, which is a claim that makes up a majority of habeas petitions. As in many states, ineffective assistance of counsel is an issue that cannot be raised on direct appeal, and it also establishes an avenue to bring up new evidence or issues which cannot be brought in direct appeal. And so this habeas corpus helps to protect and ensure that defendants receive adequate assistance of counsel in a fair trial.
I don't agree that habeas corpus should extend to non-citizens. So I want you to do is convince me why my reasoning or thought process is not either consistent with the founding fathers' ideals or with other provisions of the Constitution.
The 2004 case, Razul v. Bush, ruled that habeas does appeal to non-citizens. And this was relating to the United States having jurisdiction over Guantanamo Bay. But this case ruled that habeas does apply to non-US citizens.
And on this point, the fact that the law does apply to non-citizens means that if they were not granted this protection of habeas corpus, it would perhaps be a tool of arbitrary imprisonment and of tyranny against people who would otherwise have no other proper legal remedy to secure their rights.
And one of the important ways that this actually does play out is through immigrant rights who are detained in, say, ICE detention centers, because the US retains enough sovereignty over those places that they wouldn't have any other options. And so one of the ways that this does come into effect is that they can use habeas as a remedy for prolonged detention. So if they're held for over 90 days after their deportation order is made, they can use habeas corpus to contest that and be released.
But why should we extend? I understand that they would have that non-citizens being held in Guantanamo or ICE detention centers would have no real recourse other than through habeas corpus. But why should the United States extend habeas corpus to individuals deemed to be enemy combatants, which is Guantanamo, or people who might be looked at as invaders, which I think the immediate past president used in terminology describing what was happening at the southwest border. So why should habeas corpus extend beyond United States citizens? Convince me, convince us.
I believe it should extend beyond the territorial United States, following the Supreme Court case Braden v. 30th Judicial Circuit Court of Kennedy in 1973, in which it was found that the writ of habeas corpus actually acts upon the custodian of the prisoner, not the prisoner themselves. So the issue is whether the court issuing the writ has jurisdiction over the custodian. So as the United States is in control of Guantanamo Bay, and these people who are at Guantanamo Bay do not have access to Cuban courts, I believe it should extend so that these prisoners have something to try themselves.
The lack of an extension of the writ of habeas corpus to say those deemed to be illegal enemy combatants could raise certain constitutional issues. For example, the Eighth Amendment doesn't specifically say that citizens are safe from cruel and unusual punishment, but instead that cruel and unusual punishment shall not be inflicted.
All right, we're low on time. Was Lincoln right or wrong to suspend habeas corpus?
I do not think Lincoln was wrong to suspend habeas corpus, because when he suspended it, Congress was not in session and it was an imminent threat to the nation. And in his July 4th address, he said, must a government, he said, are all the laws but one to go unexecuted and the government itself to go to pieces, lest that one be violated? So I think his suspension upheld the nation.
However,
Although
I do agree that it was Can I finish my thought?
Nope, he finished his, so we're at time.
Okay.
All right, good job. Yay. All right, now we're going to do feedback.
All right, I guess I'll go first. So, yeah, I hate when that happens when you're in the middle of a sentence and your time runs out, but you guys did a great job, and don't let that throw you. I thought you did a really nice job on setting out, just the whole historic context of habeas. Love the reference to EDPA, dealt a lot with that in my prior job as the circuit executive. And believe it or not, it was a lot of interpretation. EDPA was in 1996, so we spent a lot of years with the Second Circuit trying to figure out what exactly did Congress mean. But I loved how you really walked us through habeas. I really liked how you talked about the importance of habeas in the Bill of Rights, really set us straight that habeas is, I love what was it? The habeas is the remedy. I thought that was a great phrase, really great phrase, just, sort of crystallized it for me. And I loved your answer about Lincoln, I love sort of, we could almost do like speed habeas corpus, but thanks, it was great. I love the conversation, wished it could have gone on.
I concur with my colleague that I wish we had more time. You guys really had a very good understanding of habeas corpus as a technical remedy. Really had a good grasp of that. Glad you mentioned the Judiciary Act of 1789. I think that's fundamental. And you guys did a nice job of walking us through kind of the expansion. I thought that was particularly well done in your opening statement. I really liked how you focused on this as a reasonable burden. You guys just really did a nice job communicating that clearly in a way that we're only going to hear this once, and you guys really made sure we got that. Just a great conversation. We hadn't heard the Five Nights case today. You guys really threw out some great examples, and you were able to do it clearly, concisely, and I congratulate you for that.
Okay, well, I'm going to keep up the good news. You guys had the bar set high for you. You achieved the standard that I was anticipating from this team. I really thought your prepared statement was solid. I have to say, but that's a poor statement. It was extremely well done, and it showed a nuanced understanding of the subject matter. When MJ, you talk about the assumed right and how then it was codified and recognized subsequent case law, subsequent acts. Now that's a sophisticated and nuanced understanding of the subject matter. And then I loved how you also, everybody essentially came back to the Federalist 84 to find the substantial basis for why this was so important. And if you have that belief and then all your arguments was consistently weaved that structure through it, then you tied into the Blackstone and the structure of the government. And I'm going to tell you again, I thought it was a very sophisticated argument that you guys were making. We hit you with at least I hit you with a provocative question because I wanted to draw you out a little bit more. Handled that smoothly, and then you took it to the more modern day references with the ICE situation. And we're going to keep facing it because there's concern that we're under attack, however you want to phrase it, by coming to the United States, either illegally, legally, what have you. So that's always going to have that tension. Very well done. Thank you. I really appreciated it.
All right, yay, good job. I'm going to go ahead and make sure our recording goes up